The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon or good morning, everyone. My name is Erin Page, and I'd like to welcome you to today's Litigation in Light of COVID-19 webinar. Our topic today is going to be patent and trademark litigation. Before we get started, just a couple of quick announcements. The first housekeeping announcement is that you might have noticed that you're in listen-only mode. This is to cut down on the amount of background noise and give everyone a chance to hear the presentation. However, you are more than welcome to ask questions during the presentation using the questions button on your GoToWebinar pop-up, which should still be on your screen. We welcome questions and we'll do our best to respond to them promptly. Second, today's session is not for CLE credit. It is an informational webinar and we do welcome questions, but no CLE credit has been created for this particular session. All right, with that, I'd like to introduce our presenter for today. Michael Sander is the founder and managing director of Docket Alarm. Michael, if you are ready.
Thank you very much, Erin. Thank you all for joining today. This is episode 5 of our litigation in light of COVID-19. It's amazing we're actually already at week 5 of this, but we've been doing one of these every single week. I'll be reviewing a few of them from the last few weeks so you get a flavor of what's going on, and we're going to just jump right into patent trademark litigation. Just quickly, a little bit about us, who Docket Alarm is, who I am, and who Fastcase is. My name is Michael Sander. I'm the founder and managing director of Docket Alarm, which is a litigation analytics company. The idea is I was really an engineer in a previous career, then went into law, and specifically patent litigation. I was a patent litigator for about 3 years, and during that time, 4 years, and during that time, I developed a tool which can analyze many lawsuits. This tool grew and expanded. It started getting used at the law firm. It expanded beyond the law firm. I quit my job to do this full time, hired a bunch of people, and Docket Alarm slowly morphed into what it is today. In 2018, Docket Alarm was acquired by Fastcase, which many of you may be familiar with. Fastcase serves over hundreds of thousands of attorneys across the country, either through their bar membership or through their law firm subscriptions. The Docket Alarm is kind of the docket analytics component. Fastcase is the legal research statutes and regulations component to the overall research system. Docket Alarm does a few functions. This is not a webinar about Docket Alarm by any means, but you'll be seeing how we use these tools to actually tell a full story of what's going on in litigation. And that's kind of part of what I wanted to talk about today. So today is not really a complete survey of coronavirus cases or litigation over them. It's not really going to be specific guidance in one particular area of practice or law. I know we're talking about patents and trademarks. These are going to be interesting and intriguing. This is not intended to give your firm specific guidance in these areas. What it is, though, the goal really is to try to give you tools so that you can actually find this information out on your own. You can stay up to date on litigation, track litigation, see what's going on during this pandemic, and to keep your practice current with everything that's happening. So just an outline of what we're going to be talking about today. I just want to do a very quick recap of prior episodes. We have episodes 1 through 4, and rather than making you watch all 4 of them again, we're going to try to do them all in about 5 minutes or less. Then we're going to go into a COVID-19 patent case. This is a pretty interesting case. There's been a lot that's already been written about it, but there's quite a few angles that have not been discussed at all in the press, and I'd like to review them with you. And then also we're going to go into a trademark case that was just filed this week, actually multiple trademark cases that were filed this week, all relating to COVID-19. These are all both very interesting cases in many ways. So just a quick recap of prior episodes. This is kind of our outline of our recap. This is one of the episodes we really went over standing orders and continuances. Then in another one of the episodes we went into legal analytics and as it relates to criminal law, and I'll show you very quickly what that looks like. And then we also talked about class actions. This is kind of a spread over the 4 previous episodes. So just quickly, standing orders. one of the things that many people do not realize is that standing orders are often fashioned as docket sheets. So if you do a search on a docket software system for COVID-19 standing order, you're going to get a lot of results. And in the previous week, I went through and we actually went through all of the standing orders that were listed for the Southern District of New York. And you can just see how many there were, sometimes multiple per day. It's gotten quite, I just did an update for this yesterday, today. And it's quieted down quite a bit, but as the court reopens, we can definitely expect to see more and more of these standing orders. So as the restrictions start loosening up a little bit, we'll see another, rest of standing orders coming in. In addition to standing orders, many cases are having continuances and delays. Almost all of them are granted. However, they're not always granted, as a matter of course. Sometimes there's some motion practice about them. We went over a few cases of this in the previous weeks. Actually, we'll have another example to show you today. That's also pretty interesting within its context. In addition, last week, I think this was 2 weeks ago, we went over some analytics. So for those who are unfamiliar with what litigation analytics really is, it's a tool that we can use to analyze thousands of cases all at once. So rather than going through case by case, reading each individual one, you can get a high-level picture. And I'll show you kind of what we did in the previous weeks. We did a batch of analytics on federal criminal cases. And what we were trying to look for is really trying to see how often lawyers are making motions for release of custody due to the coronavirus. And here I just actually updated a chart. Here's the daily, day-by-day filings for motions for release from custody due to COVID-19. And you can see kind of the weekly rates are just jumping up considerably week by week. And then I kind of took the data yesterday, so you can see kind of drop, but that's probably just because of a data issue. But you can kind of see this upward trajectory as cases kind of increase. The motions for release from custody are also increasing. So this is something we were able to show through analytics. And we'll be able to show you some more interesting stuff today. Shifting gears, last week we talked quite a bit about class action lawsuits and all the different types of class action lawsuits that are going on. There are so many. And in addition, we showed you how to find your own, basically do these types of searches on your own. Basically using the different search tools that are within Docket on how to actually find class actions. Some of the class actions that we spoke about last week were the Zoom privacy class actions. Actually, as of last week, there were 6 different class actions that were filed. I'm pretty certain by now there's more. There's FTC actions. There's Attorney General actions. There's quite a few. There were quite a few class actions involving Zoom. And actually, you can just take a quick look and just to see it again. I'm just kind of curious if this number increased. I bet you it has. So I just copied and pasted that search right up here into the search bar. This is what this search is doing. The goal of this search is to find cases where Zoom is a defendant. When one case is coming up, I know that I'm doing something wrong here. We'll come back to this in a few minutes. But anyway, so the Zoom cases are one set of class action lawsuits that are pretty interesting for heavy privacy reasons. We also talked about a large class action that was filed against United Airlines over refunds for canceled flights. In addition, there was class actions against state governments. There was also class actions against federal governments. In this particular state government class action, there was really this was an action brought on behalf of the prisoners that are being kept in Texas institutions. And fun tidbit here is that these inmates were being pressed into manufacturing alcohol-based sanitizer at the prison, even though they're prohibited from using it themselves. So there's quite a few different issues that are going on. There's also a fraud case over quackery against a church leader who's selling a product called Silver Solution, which one of his representatives has said Silver Sol has been proven by the government that has the ability to kill every pathogen that's ever been tested on, including SARS and H1N1, previous coronavirus type viruses. They're being involved in a very large fraud lawsuit. So kind of the takeaway here is really, there's quite a lot of activity that's going on. All these activities actually can be found in the docket sheets, and you can actually pull out quite a bit of interesting new cases and research using tools like this. That can be very helpful for staying on top of what's going on in litigation during this time. All right, so right now I'm going to jump right into the main topic of today, which are patent and trademark cases, and we're going to kind of go through in detail some research that we can do to kind of find out more information about these cases than would otherwise be reported in the press. And after doing some research on this myself, I had to include a pretty important side story that's going on in this patent case. And we'll go into the side story that takes some meandering turns, but it's a pretty interesting case. So let's just jump right into it. How do I even find cases involving COVID-19 that are relevant? It's actually pretty easy. You have a search bar that helps you do this. So all you have to do is go up to the top. Up here, I want to just search for the words COVID-19. And then over here on the bottom right, you just check uncheck documents. And we're only going to be searching for pleadings. So I'm going to uncheck opinions, motions, exhibits. And then boom, all the cases come right up. So there's quite a bit of different material. I went through this and narrowed this down a little bit more when I was doing my research. I got rid of a lot of IP cases the trademark applications that are being filed related to COVID-19, but there's quite a bit in here. And one of these cases is indeed a patent suit brought against BioFire Diagnostics. So BioFire Diagnostics is a company that does testing for a wide variety of different types of diseases. Labrador Diagnostics, the plaintiff, it's really a shell company. They're owned by a investment firm called Fortress. I think they're Fortress Financial is the full name. Fortress Financial, in turn, is owned by SoftBank, which is the largest venture capital company in the planet, with I think it's $100 billion under management. So this is a kind of a small-time patent plaintiff's case backed by very, very large players. Already, it sparked quite a bit of interest. And the key thing that really set off the firestorm was looking into the complaint. The claim that they're actually, claiming against is actually reading onto a product that has that includes a detectable signal indicative of the presence of and/or concentration of various viruses and bacteria. So they're suing a company that does tests for viruses and bacteria. And it just so happens BioFire, the company that's doing this test, is also making COVID-19 tests. So this is the first patent case that we've seen against a test maker for COVID-19 tests. Things got even more interesting once you took a look at the patent itself. So here's the patent's 8283155. The next thing you would do if you're involved in a case or interested in looking up what this case is about is to look up the patent. And what's the patent's on Docket Alarm, but Docket Alarm actually has more than just the patent. It has a full prosecution history. So we can actually see all the inventors, all the inventor statements, all of the discussions that were happening during the prosecution of this patent. And here's the case right here. Actually, let me just pull it up. We have the link. So here's a case, and here's the full history. You can see that this patent was first filed for way back in 2009. And over time, there's been quite a bit of activity, and then they basically got, at some point in here, they actually were granted the patent, and you can see all of the history that led up to that. The really interesting thing, though, is that Elizabeth Holmes and Theranos are involved in this patent. I'm not sure if everyone on the call is familiar with Elizabeth Holmes. She's listed as an inventor. She signed her name onto the patent. Elizabeth Holmes is pretty well known in the venture capital and biotech space. For years, she was a media darling. She was a dropout from MIT. to start a company, a testing company that would test for a variety of diseases using a revolutionary technology that would basically, with a single fingerprint prick, would draw enough blood to run a whole slew of diagnostic tests in minutes. Currently, the way that diagnostic tests are being run, you have to actually blood withdrawn, sometimes multiple times from multiple parts of your body, has to be sent into a testing lab. I think it could take days, sometimes a week, to get your test results back. So the idea of a single fingerprint where you can read all the information you need was pretty revolutionary. The problem was the technology didn't really exist. The Wall Street Journal started to do an investigation into the venture capital, into the startups company, Theranos' company, and they found that the technology that they were marketing wasn't really being used at all, and they couldn't find any evidence of this small fingerprint technology actually working. This grew into a whole slew of articles by the Wall Street Journal, kind of carefully taking apart this company brick by brick until the entire thing entirely collapsed. And back in 2018, it kind of really came to a head where Theranos founder Elizabeth Holmes was actually indicted on fraud charges. And this is kind of where this kind of side story really gets to a side story. I had to look up what are these fraud charges about against Elizabeth Holmes. I went to take a look at the docket sheet. It's right there. It's in the Northern District of California, USA v. Holmes. And what's really fascinating about this is that they have right on the docket, we list, one of the things Docket One can do is we extract the scheduling orders that are coming up. And on the docket sheet, there is a notice saying that jury selection is set for October 27, 2020, and jury trial is set for later on that day. So they had a trial on the calendar ready to go. And then I also noticed that there was actually quite a bit of material that was even filed. There were some filings even in the past 2 days. So this is a document that was mentioned in Elizabeth Holmes' case. Just filed, I think this is on Tuesday. And they were talking about the scheduling order. So I went to take a look at it, and the government, they're basically arguing back and forth of what should happen with the schedule. The government was pretty terse in their remarks. The government submits that this case may proceed to trial either as scheduled or by October 2020. So really, the government is pushing ahead for this case, and they really didn't want the coronavirus or COVID-19 pandemic to affect the schedule. Then in the same document, Elizabeth Holmes, her attorneys, write a statement. This is where it gets a little bit interesting. She said, with respect to the current health crisis we are now facing, we recognize many tasks and activities associated with trial that all counsel once would undertake routinely and without hesitation, which now carry risks. The trial will be months long, and the court will be crowded. The defense, jurors, and witnesses will all enter the courthouse through a crowd of onlookers who have often approached and even touched counsel and the defendant during entry to the building. So really, they're anticipating a pretty, a press-heavy media event. I mean, this trial certainly will be one. And there's a particular dangers during the pandemic of running one of these. And this is the kind of back and forth horse trading we've seen in a lot of cases. It's not so simple in most litigation to just ask for continuance and get it. They're almost always granted, but there's still some back and forth with the opposing counsel. And she goes, the Holmes and her attorneys go further. As noted above, given the risk and considerations, counsel for Ms. Holmes proposed to the government that we defer the trial for approximately 6 months and plan to proceed in early 2021. The government was unable to agree to adjourn the trial date for that length of time. It maintains that the case can be tried in the fall. And then they kind of go on and further in this document to kind of talk about a compromise that they reached where they defer some things but not all things. And, there's this horse trading that's going on. The judge actually ruled on this the next day in a one-page order, which was pretty rudimentary. I doubt that the judge actually wrote this. It's probably written by the clerk, where basically the judge just deferred at all deadlines. So they didn't try to schedule another trial for 2021. They basically pushed everything back. And this really kind of just is the reason I'm bringing this up is a very good example of the types of back and forths that are currently happening. It's very emblematic. A lot of cases you ask for continuance, The other side doesn't really complain. I've not really seen any continuances being denied in the past few weeks. Showed one where it was denied about 4 weeks ago. But what is still happening is this horse trading of what dates the shift and when exactly. And depending on your judge, you know, it might turn out one way or the other. So that was kind of the end of my diversion into Elizabeth Holmes' criminal investigation, just because it was very relevant to some of the topics we were talking about earlier. Let's go back to the case. Really, now that you have a little bit of background on who she is and what's going on with this company, you know, when this lawsuit was first launched, there was a huge amount of media attention. You know, some writers here, I forget, this is at the Register. Theranos Vampire lives on. Owner of failed blood testing business patents sues maker of actual COVID-19 testing unit. And then other articles kind of mentioned the link with SoftBank, which is this large venture capital company. So there was quite a bit of pushback. And I kind of wanted to dig into this myself. It's like, is this really what's going on here? I mean, is the company really trying to take down a COVID-19 testing company? It seemed unlikely that someone would really stoop that low. Especially actually looking at the the complaint in the case. It's a very detailed, well-organized, complicated complaint with a large number of charts and diagrams, and it's clear they spent a huge amount of time drafting this complaint. It's not something that would just be, you know, hobbled together just in the midst of the crisis. In addition, I took a look at the law firm. Actually, I ran some analytics. These are legal analytics. I'll show you a few other legal analytics coming up in a minute. But these analytics show that this law firm, law firm, I wasn't too familiar with them beforehand. They have a very good amount of experience. They've operated in Delaware and across courts across the country. They're a national law firm. I don't think they're very large, but they probably have around. Actually, I haven't even looked. It says it here how many attorneys they have. But they have quite a few attorneys, and not to the level of a 1,000+ attorney firm. And it just seems surprising that this law firm would try to do some tarnish their reputation this way, or would allow for their reputation to be tarnished. And sure enough, a little bit more digging, I found a press release saying that Labrador Diagnostics, a plaintiff, today announced that it'll offer royalty-free licenses to third parties to use its patented diagnostic technology for tests directed to COVID-19. So the truth is, they really weren't suing over COVID-19 testing. They were suing over general testing technology. I'm sure, based on the length and the detail of this complaint, it was probably prepared, or was being prepared for months. It's very unlikely this is really a COVID-19 patent case, even though that's how it's being portrayed in the media. And now with this royalty-free license that they're granting, I think we probably expect this case to kind of fade from the media's attention as time goes on. So that's a kind of first half of IP litigation. I'd like to talk about the second case. This one really is a true COVID-19 case, not just a patent case or IP case that got caught up in the COVID-19 pandemic. So here we're talking about a case brought by 3M. This was brought just Monday of this week. 3M, as many of you know, makes a wide variety of products, but what they're most famous for right now is producing the N95 masks that are used by health professionals across the country as personal protective equipment. This case was filed Monday, and it was brought against a company called Performance Supply, LLC. And really, if you dig into the complaint a little bit, it lays it out very clearly. This lawsuit concerns defendants, Performance Supply's use of 3M's famous 3M trademarks to perpetrate a false and deceptive price gouging scheme on unwitting consumers, including agencies of government during the global COVID-19 pandemic. So, the first sentence that they're using the 3M trademark here as a legal hook. This is really a price gouging case, which is pretty interesting and uncommon. Going a little bit further into the complaint, they kind of talk about the different wrongdoers who are involved in these schemes, and they talk about the different scams that are going on. These scams include unlawful price gouging, fake offers, counterfeiting, and other unfair and deceptive practices. So, for those who study trademark law, counterfeiting and deceptive practices are pretty common. You can pretty commonly find them in trademark litigation. Price gouging is not really a common trademark claim, and we'll go into a little bit more of the detail there. It's a pretty awkward way of using trademark law. Going further, they set out a few of the facts of the case. I could have laid these facts. I really like using the primary sources when actually laying out these facts, and I think the complaints generally do a pretty good job at that. So let's just read this. On or about March 30th, 2020, defendants, this is Performance LLC, sent a formal quote to New York City's Office of Citywide Procurement, offering to sell millions of plaintiffs' 3M brand N95 respirator masks at a grossly inflated aggregate price of approximately $45 million. Defendant is not an authorized distributor of any of plaintiff's products and has no right to use plaintiff's famous 3M marks. Nonetheless, to confuse and deceive New York City officials into believing the defendant was an authorized distributor of plaintiff's products, defendant reproduced the famous 3M marks throughout the formal quote and attached it to the technical specification sheets. So, after looking at this, it's clear that they're using their trademarks as a hook to prevent price gouging. You have to see it, right? So this is actually the quote that they supplied. They attached the whole thing as an exhibit, and we can go through it. I will bring up the quote in full, but the key thing I just want to bring out is just, it's kind of shocking during this pandemic to just see what's going on here. So this is just a blow up of the quote, and you can see that they have a quantity 2 million of these versions. These are all N95 masks. They're just a different kind of format. N95, for those who are not familiar, refers to the protective material itself, and different versions of N95 might have, rubber straps or plastic straps or kind of a little bit more bulked up packaging of the product. So here's two different versions of the product, 2 million of one and 5 million of the other, selling them at $6.05 and $6.35. The list price that's 3M quotes is around 65 cents for each of these masks. So this is a 10x markup for these masks, and it's pretty shocking to see this actually written out on paper. Further, you can just going down into that quote. They also have other terms that are kind of used, and it makes it appear that there's some affiliation between Performance Supply and 3M, and in their shipping section, they say due to the national emergency, acceptance of the purchase order is at the full discretion of 3M, and supplies are based upon availability. So they're kind of representing themselves as a authorized middleman of 3M, selling at a 10x markup. And I just want to pull up the exact. Oops. Go back. I'm going to pull up the exact exhibit so we can see it. So here's the exhibit in the case. The first page is that same order form that we saw before. And this is what they were talking about, the technical specifications sheet. This is what 3M is alleging is violating their trademarks. And it looks as if these are 3M produced marketing materials. So they're really suing them for using 3M's own marketing materials and suggesting an affiliation. And then that's their hook to trigger a trademark liability. So this goes on. They have more of the technical specifications here, and there's some quality assurance documents. So this is pretty interesting case. And the next thing I wanted to do before going into the next thing was really to see, okay, why Performance Supply Company? Are they the only ones that they found, or who is this? Is price gouging a common concern for 3M? Is it only coming up in light of COVID-19? Have they been doing this in other contexts, in other areas? So, the next thing I did is actually build some analytics on 3M's offensive litigation. And if we have time, we have about 10 minutes, I'd like to come back to this to show you a little bit more about this and what you can learn from these analytics and what I learned. But one of the things I learned was, no, this is not the only lawsuit that they've brought. Here are 3 other lawsuits so that they've brought pretty much on the same grounds. And I looked at the complaint for each of these, and the complaint is clearly, there's similarities between them all. So of these 3 others, 2 of them are in federal court. One's in California, one's in Florida. And then there's this other one that's kind of oddball. It's in Texas State, Dallas County. So it's a Dallas County District Court. And a part of me I was wondering why Texas? And why bring this one in state court when you brought all the other ones in federal court? And I kind of looked into it. Let's just bring up the case. I want to get ahead of myself. I'll bring up the case for the Texas State Court one. Here it is. Who's representing them? Actually, the attorneys on all these cases are the same. I think it's Mayor Brown. So it's a large law firm that's representing them. So let's just bring up the complaint or petition, as it's called, in Texas State Court. And the complaint looks pretty similar. And if you take a look at the cause of action, they're all pretty much the same as the federal cause of action. So it does kind of remain to me a mystery why they brought this one into state court. But that's something I think we could probably tease out with analytics a little bit more. One of the things I wanted to show you in the complaint, I'll just bring it up in the PowerPoint, is they also have their own, this is a completely separate lawsuit against a completely different defendant. It's also for exactly the same cause of action, price gouging. And this one also, even though it's brought in Texas, involves New York City. This is an email that was attached to the petition in the Dallas court case, and it's from Daniel Simon, who is the New York City Chief Procurement Officer. And some of this is redacted to protect the identity of some people involved in defendant's operations. But this is an email from Daniel saying, we need to see proof of life of these masks. It's an interesting term to use for the masks. They need to have some sort of proof that these millions of masks that they're purchasing exist. There's 20 million masks in New York City. Where can I see them? I'll drive there tonight. Just as emails like this can really show the urgency of the officials, the urgency of the activities that officials are undertaking right now. If the Chief Procurement Officer of New York City is driving around New York City to try to find masks wherever he can, no, it's an emergency. So here they're trying to do a little bit of due diligence. They're willing to expedite all the different payment terms and clear as much red tape as possible. And then in the response, this is the response from the defendant. Hi, Dan, this is the addressee, and the name of the addressee is 3M Company Trust Account. And then upon receipt of proof of funds, you'll provide proof of license and address of goods that you can expect. So, these are the emails that were going back and forth. This seems shifty, right? I received this. I'm not sure if these are, I'm not a procurement officer, but this seems like, someone's kind of mentioning the name of their company is 3M Company Trust Account, and they're kind of pushing back in such an emergency. I think that there's definitely something a little shifty going on. This letter was forwarded to 3M, who then investigated this and found that these were not legitimate players. So these are 4 different lawsuits, all kind of involving the same thing. We don't have time to go over every single last detail about each of them. I just wanted to bring out some of the highlights. But these are not typical trademark lawsuits. Really, none of these allege real counterfeiting that's going on. They're not really sure whether it's counterfeited. Counterfeiting is not a primary part of the complaint here. Also, for those who are familiar with trademark disputes, there's a first sale doctrine or the exhaustion doctrine, which basically says, after you sell something, you lose after you sell a product, you lose substantial control over that, and IP rights shouldn't be a way to kind of recapture some of that control. This is a complicated doctrine. That's the one-line explanation of it. It also applies to patent law too, so it's a pretty, there's anti-copyright law, so there's a lot of different contours to this doctrine. But it really does put a damper on what you can kind of do in the way that you can control products after they're in the marketplace. And this is a private price gouging action. There's many public price gouging actions where attorney generals bring, but this is really a private one, which really makes it pretty atypical. Here's a quote. I just found some commentary on this case. This came out this week from attorney at Holland & Hart. Under the exhaustion doctrine, once a manufacturer sells a trademark product, the manufacturer can no longer control how that product is resold, unless it does so contractually. There's more contours than that, but that's generally the case. In addition, the next thing I wanted to do was I was like, okay, well, this must exist somewhere, right? I searched through all Docket Alarm, I searched through Fastcase and other legal research tools for price gouging, as it relates to trademark, and I have not found any cases on this at all, not a single one. There is some dicta that talks about price gouging, and sometimes there's cases talking about price gouging but used in the opposite way. It's people with trademarks kind of taking advantage of their trademarks. 3M's kind of doing, they're kind of trying to be the good actor here. So there's nothing really on point. So this is a pretty novel case, and kudos to the attorneys at Mayer Brown who came up with it. And the truth is, even though it's a novel case, and the chances of winning are pretty slim, it's clear what's going on here. Sometimes a party can bring a weak claim to achieve a greater good or higher objective. These cases are as much for the media attention and for the show force than they are for actual legal grounds in which they stand. So that's the kind of the basic gist. I just want to bring up and show you some of these analytics before we hop into our conclusion, because we have about 4 minutes left. So these I'll try to finish these off at 12:40. So this is just a very quick set of analytics that I built on 3M. And what I did is I wanted to take a look and show, or actually I already have them up. What am I doing? I want to show just a little bit of the types of data that you can pull out of this. So what we're looking at here is 3M's offensive litigation. I only tried to find cases in which 3M was acting as a plaintiff, as a third-party plaintiff, as a cross plaintiff, or some sort of plaintiff, and look at their cases over time. There are many cases where 3M is a defendant. They get sued all the time, product liability, patent infringement, you name it. Much fewer cases where they're actually a plaintiff and actually bringing action. But they still definitely do. And you can actually see 2020, this year, has so far been their #1 blockbuster year for suing people. You can see the law firms that they use, Fager Daniels, and scrolling down further, you can see their top attorneys, but I want to show the case types. Was that in a different tab? Here's a case type. So this is their top case types. They bring patent and trademark cases all the time. They're involved in multi-district litigation. There's contract cases. They even have some property cases and tax cases involving that property. So they're actually no stranger to litigation. And I just also wanted to show the fact that they were, I'm just going to do a date search. You don't have to look all the way back. This is like the last 5 years. I just wanted to show their attorneys that they have over time. Because, they've been using Fager Daniels. Oh, I cut it off too much. I cut off too much of their history. But what I wanted to show is that they've been using this one law firm for quite some time, Fager Daniels, and what you can see is that over time they've actually shifted quite a bit. And it's just kind of interesting to see how firms change over time. So here the green and the red are Fager Daniels. They changed names so it can get a little confusing in there. And they've used them for quite some time, even recently as up to 2018. And for this case, they didn't use them at all. So it just kind of shows you can see not only how the types of cases 3M is bringing is changing, but also the law firms that they're using are changing as well. This is just the kind of data that you can pull out of litigation analytics to kind of get a full story of what's going on. All right, so that's the last little bit. I know that was not entirely, that was really intended to show you how you can use tools like this to find out more information. I was using these tools to find these cases. I was using them to figure out what 3M was up to when developing this presentation. So just going to conclusion, kind of run through some of this quickly. There was lots to cover though. There's plenty of information in the dockets. Pretty much all news stories you find out about legal news stories come from the dockets in one way or the other. And as you saw here today, to kind of build this up, I use both traditional search tools as well as analytical tools to kind of build a deeper story of what's going on in these cases. And that's kind of what a lot of attorneys should be using today to kind of figure out what's going on in their cases, to track their cases. You kind of have to rely both on the traditional tools that they're used to and supplement those tools with the newer ones. You can get more information, get that information a little bit more quickly than you otherwise would be able to. So kind of substantively, we just showed you kind of an example of an existing IP litigation kind of being sidetracked over COVID-19. This was not a COVID-19, the patent case that I showed you was not a COVID-19 patent case. It just kind of got caught up in the mix. And they quickly want to distance themselves from that. In addition, we're also seeing new types of actions. I'm actually, for one, pretty interested in keeping up to date on these cases and seeing which of these 4 cases actually go anywhere. Very likely they'll all settle, or get dropped in some way or another. But in an unlikely event, these actually go to trial and we get an opinion out of it. It would be interesting to see price gouging as another cause of action under trademark law. So that's the last bit of it here. Here's the end of my COVID-19 presentation. Thank you all for joining. I hope you learned a little bit about some interesting ways patents and trademarks are being used in the in light of COVID-19. And I hope to see you next week. If you have any questions, feel free to ask them. Thanks very much.
Hi, Michael. That was great. So we do have a question from our during the meeting question box. The question was regarding one of the trademark cases where you're speaking to it being more of a price gouging case than a trademark case. The question was, if there wasn't a trademark hook, would 3M have standing to raise a price gouging claim?
So I am not familiar with all 50 states' price gouging laws. From my understanding is that most cases are brought by the AGs, by the attorney generals. I have seen cases brought by attorney generals. I think in one of my prior episodes we actually we reviewed one, but briefly. But they're normally state court actions, so it's kind of state by state. It would not surprise me at all if there's some in some states have private right of actions for price gouging. That would not surprise me, but I am not familiar with that. That's probably a kind of more of a tort law type of question. I would bet they exist, but I haven't seen that. So I think to answer your question, without the trademark hook, yeah, it would be very, very difficult for them to bring these. And they certainly would not be able to bring them in like full force, like bringing 4 lawsuits all at once, like they've done here. It'd probably have to be a lot more nuanced. Any other questions?
That's the only question we have. So I will go ahead and say that if anybody has any questions that come up after this event, please feel free to reach out to us. You can always reach out to us at support@docketalarm.com. And we'd like to thank you for joining us for today's webinar. We hope that you got some value out of it and that you'll join us for future webinars. Keep an eye out for other sessions, and we hope you have a wonderful afternoon, everyone.
Oh wait, just one last pitch for the next episode. So next week we're actually going to be talking about. Sorry about that, Aaron. Next week we're going to be talking about video conference hearings. So for the first few weeks, just to give you a preview, the first few weeks of COVID-19, pretty much everything was canceled or continued. Now that we see this pandemic lasting quite some time, a lot of courts are making preparations for video conference of hearings, but via video conference. So we're actually going to have a guest speaker next week who's going to be talking about her experience doing a video conference hearing, what that was like, and we'll be trying to determine how often these video conference hearings are occurring across the country and what different attorneys are doing in response to them. Thanks.
Excellent. So I do hope everyone will join us for the next webinar. And again, please feel free to reach out to us if you have any questions.
Thank you. Bye-bye.